Head Note A. Test Identification Parade. Whether compels accused to be a witness against himself? Accused while subjecting himself to the TIP does not produce any evidence or perform any evidentiary act. Identification of him by a witness is not his act, even though his body is exhibited for the purpose. TIP does not violate the fundamental right of an accused under Article 23 of the Constitution. Head Note B. Test Identification Parade. A statutory prerogative of investigating agency. After the introduction of Section 54A in CRPC, an accused is under an obligation to stand for identification parade. An accused cannot resist subjecting himself to the TIP on the ground that he cannot be forced or coerced for the same. Head Note C. Test Identification Parade. Witnesses had a chance to see accused either at the police station or in the court, cannot be a ground to refuse to face the TIP. Open for the accused to raise any legal ground available to him relating to the legitimacy of the TIP or the evidentiary value of the same in the course of the trial. Head Note D. In-court identification. Reliability is the linchpin in determining the admissibility of identification testimony. Factors to be considered are the opportunity of the witness to view the criminal at the time of the crime, the witness' degree of attention, the accuracy of his prior description of the criminal, the level of certainty demonstrated at the confrontation, and the time between the crime and the confrontation. Head Note E. Test Identification Parade. Substantive evidence is the evidence of identification in court, and the test identification parade provides corroboration to the identification of the witness in court, if required. What weight must be attached to the evidence of identification in court, which is not preceded by a test identification parade, is a matter for the courts of fact to examine. Head Note F. Robbery and Murder. Evidence of injured witness regarding the occurrence fully supported by the medical evidence. Injured had more than a fair glimpse of the assailants at the time of the incident, and on the strength of the same, he identified the appellant as one of the assailants. Appellant refused to participate in the TIP as the eyewitnesses had already seen him, except a bald assertion. No other foundation has been laid for offering such an explanation. Weapon of offense, that is ice pick, which was ultimately discovered from his house at his instance. Even if evidence of discovery is discarded as no independent witnesses associated, still the fact that the appellant led the police party to his house and handed over the ice pick used at the time of the assault would be reflective of his conduct, relevant in terms of Section 8 of Evidence Act. Conviction upheld. Head Note G. Premature release. Appellant has undergone more than 16 years of sentence. Representation to be addressed to the competent authority of the state, NCT of Delhi, for premature release, which would be considered in accordance with the policy prevailing at the time of commission of the offence as regards remission.